Thank you so much, ladies and gentlemen, for joining us. Welcome to this webinar meeting by Tenacity Business Solutions. My name is Emmanuel Malingi, the Technical Solutions Manager of TBS. Welcome to this engagement on data protection. As TBS, we offer dynamic and innovative high-quality products and services in various fields, including data protection, consulting, information security, and business consulting. Our discussion today or our engagement will be based on data protection because it is one of the major concepts that every business, every organization needs to understand and be able to know the regulations that normally govern how you can be able to be safe within your organization in terms of handling data. Tenacity Business Solutions has its core values that stand on integrity, customer focus, excellence, and diligence. So we are guided by our mission and vision, whereby we provide innovative and customized solutions to empower clients to achieve their goals. We are also guided by being the leading providers in solutions of our businesses that we do, organizations, so that we can actually be able to achieve our goals. So in this discussion today, or in this seminar, you will be informed on ways on how you can be able to protect your data and on data protection regulations that were put in place by an effect of an Act of Parliament of 2019. And that will be done by our main speaker, Mr. Duncan Nyale, who was actually a member of the task force that actually came up with the regulations that we are supposed to follow as practitioners within the field of data protection. So up to this juncture, I will welcome Mr. Duncan Nyale so that he can be able to give his presentation. Mr. Duncan, welcome.
Thank you, Emmanuel. Like Emmanuel said, I think we are one-stop shop for data protection services. And this is a first of many webinars we are hoping to be able to do. And we sincerely thank you for joining us. And I'll take maybe 30 minutes or so to just take you through basically what data protection is. I just want to unpack data protection, and then after which we'll have a Q&A. I know every time we have an engagement on data protection, there's usually more questions than the presentation we want to make. So I will make time for that. And even probably for those who have time, just extend a little bit for you to be able to ask as many questions as you can. Just confirm to me that you can actually see my screen and whether I'm visible.
Yeah, we can be able to see the screen and you are not seeing. Yeah.
Okay, thank you. So I'll go straight into it. And basically what we want to unpack is what is data protection, what are the concepts around data protection, and basically try to break it down in such a manner that each and every one of us can be able maybe to appreciate what it is. I'm informed my camera is not working. I don't know if that's the case. Just a minute, give me a minute. Just a minute. Okay, I think we'll just get to it because of time. Sorry about that. Okay, so basically a background to the Data Protection Act of 2019. I think most of us are aware that it was assented to in 2019, that's the 8th of November. And of course, it took effect 2 weeks later. That was on the 25th of November, 2019. But what is it basically? In a nutshell, it's an act that, excuse me, I'm a little under the weather, so you'll excuse me. It is basically an act that confers certain data protection rights to individuals, or what we call data subjects. And by default, these rights prefer a responsibility, or what we call obligations, to us as organizations. And basically, that's what we want to have a conversation about. So how do we identify what qualifies to be covered under the Act, and what does the Act expect us to do as organizations when handling this particular information? So data protection, in simple terms, if you are to define it, it's those two red words in red. Data protection is the fair and proper use. You can replace information with personal data about people, clients, suppliers. So any data about a person that you keep, it doesn't matter what role they play. Are they clients? Are they suppliers? Are they your customers? If you store data about people, then you are covered by the scope of the Act, and you therefore have to use that data fairly. For example, you should not use data to disadvantage or to cause bias against someone. That's fairness. Then proper use of data is you should capture that data and use it for the lawful direct purpose that you said you use it for. Don't do what we call data repurposing. You take data for processing A, then you do B, C, and D without permission. So we are saying that data protection is a fundamental right to privacy, because most of the time we get questions on people asking, where did this come from? It seemed to have fallen from somewhere we cannot place. So we have to appreciate that this is one act that gives life to the Constitution of Kenya 2010, specifically Article 31, subsection C and D, which gave the fundamental rights of privacy to citizens. So this and the Computer Misuse and Cybercrimes Act and such other acts get the power from the same place in the Constitution. So we are saying that if you protect the personal data of your subjects, of course you will build trust and you will comply with the legal requirements of the Act, which I think most of us by now appreciate. Now, especially for the ICT people, how does the Act define data? Because I know in ICT, data is different from how it is defined in the Act. So that is important. So the Data Protection Act defines data as information which, so for ICT people, describing data and information as the same thing is a misnomer. But for the purposes of the Act, you have to appreciate it was not drafted by technocrats in the technology field. Actually, the task force that created the Act had no ICT representation. It is during the regulations that some of us came in to now try to give life to some of these things. So data is information, which one is processed by means of equipment in response to instructions. So simply put, it covers both digital data and analog data. So if you have data in files, you have data in your servers and all that, it is captured there. You record with an intention to process. So basically any data that you hold, relevant of a filing system. So if you generate personal data in the course of executing a mandate, like for example, you have a personal file of an employee, and then you keep building it up, and some personal information of some nature, you know, the health status of an employee can change, and you might have some of that information, maybe for medical insurance purposes embedded in that file, then that is also captured. Forms part of an accessible record. So something like maybe in the judicial system, if you're convicted of a crime and you've been in the judicial database, then that's an accessible record. Is recorded information which is held by a public entity. So, for example, COOPS takes personal information of students to place them in maybe schools or colleges, or KRA for your tax purposes and all that. So basically, all data about a person is covered with the Act. And that's why we are saying the scope of data protection covers all aspects of the data management through the data life cycle. So when you talk about data protection, most of the time people think about the storage part and how you use it, in that you don't misuse the data and then you don't lose it. But data protection covers more than just that. One, it kicks into effect from the point you start collecting that information. So compliance with data protection will start from the collection point. And the collection point is important because more often than not, this is where we can capture the concept of consent. And we'll have a discussion around that in the next few slides, because it is supreme to data protection. So you must collect data through or with express consent. How you process that data, so from the collection, from the processing, will define what processing is according to the Act. How you store the data, how you disseminate it, so whether you can share it, so you can transfer it, up to when you delete or you forget that particular person. We had a discussion at public participation about the difference between erasure and deletion. And it was a back and forth until the end. The public decided we have both. They were feeling that deleting is you remove with some traces within the system, but erasure is complete removal. I don't know how true that is technically, but that explains why both words are there in the regulations. This is from the public participation. So basically, data protection kicks in the moment you collect the data, and whatever you do with it, including storing it, until the day you lose that data or you are not in possession of that data anymore. Let me say that, not lose. Lose can mean getting lost, but that's not what I mean. Lose in terms of letting it go. You are covered within the scope of data protection. So there are some key concepts in data protection. We've already discussed what data protection is. Now, there's the concept of a subject, there's the concept of a controller, there's the concept of a processor, then there's the issue about data, personal data and special categories. Remember, data protection only covers personal data. It does not cover every data that you have. Just to give an example, for example, if you get a copy of maybe M-Pesa transactions conducted during a day, and you strip it, all personal information, you just want to see maybe how many amounts, just for statistical purposes, how much do people send during what hours, blah, 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 when is the busiest time of day, without really focusing on who is sending what. Then even if you have 2 million records, if you do not have any kind of personal information, names are not there, telephone numbers are not there, it's just the statistical analysis sheet for when transactions took place and what amount, without who did it, that falls without the scope. So it is not within the scope of data protection. However, if you release one transaction showing who sent how much to who, that is within the scope of data protection. You've broken the law. So I think that is clear to get that out of the way. Then of these personal data, there are those we call special categories, and those are the ones we call sensitive personal data. And then we'll talk about the concept of processing and consent. And then we'll proceed from there. So who is the subject? Simply put, an identifiable natural person who is the subject of personal data. What that means is an identifiable human being whose data you are holding or was held even before. But the word identifiable and natural means if, for example, you create a robot and give it names and all that, it is outside the scope. Legal entities, companies, blah, 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 they are outside the scope. They are not natural people. They are legal personas. So they are not captured by the act. So it must be an identifiable, someone with a trace. You can even create a fake name, someone we cannot trace. We don't know when they were born, if they have an ID, where they have lived. Those will also, unfortunately, fall outside the scope. So it must be an identifiable, natural person. Now, when we go to the controller, the definition changes. We are now a natural or a legal persona comes into play, public authority or agencies. So basically, simply put, a controller is an entity that determines, either alone or jointly with others, the purpose and means of processing personal data. So if you are the one who will sit and make a determination, what data do I need to pick from this subject? How will it be used? That makes you a controller. Now, this is important because all data protection liabilities lie with the data controller. So you need to be very careful to know the role that you play. You might think you don't have responsibility over the data you hold, only to realize that actually you will be held accountable if anything happens to that data, despite maybe engaging other people. So the controller, two things, determines the purpose and means of processing that data. Then there's someone we're calling a data processor. Now, this is also a natural or a legal person, same definition as a controller. However, with one distinction. For you to be a processor, you must be processing data on behalf of a controller. So that means, for example, if we as TBS decide that we are not going to process our payroll anymore, we are therefore going to engage an HR consultancy firm to do it on our behalf. That HR consultancy firm will gain access to our database of employees and their personal information for the sole purpose of processing payroll on behalf of TBS. So they will become the data processor for that particular information. I hope that is clear. There's another entity we have not mentioned yet called a third party. Now, a third party is an entity that probably gets access to personal information from a controller, but it is not processing anything on behalf of the controller. They're just doing it to further their mandate. Like, for example, if you want to train your employees, then you take them to the Kenya School of Government. So if you are telling them to the Kenya School of Government, for example, you might need to send a list of the participants for logistical purposes for KSG to plan for that training. Now you realize you have sent maybe personal information to the Kenya School of Government, but the Kenya School of Government is not processing anything on your behalf. It is for them to facilitate execution of their training mandate. So an example like that is an example of a third party. But I need to put a disclaimer here. The reason I have not defined the third party here is because it's one of those gray areas in the Act that needs a review. A third party so far does not have any obligations under the Act, which means if I send my information to a third party and they misuse it, then they cannot be held culpable. It is me who will be found culpable under the Act. But I think those are some of the things that are going to be reviewed, and a third party will be taken into account and be held accountable where they misuse data that was entrusted to them. But I thought that was important to mention, the concept of a third party. So this is just accentuating those roles. So we have a subject, we have a controller, we have a processor. So by now, I think we have identified that all of us are subjects. Okay, you have bank accounts, your employees, and all sorts of things. You have cell phones, you have things that you live your data about. You went to school, you're probably in school now, doing anything. So a lot of entities hold your data, and therefore we are all subjects. And we're also controllers, because most of us represent organizations that hold data about different people. So subject, controller, processor, add third party to that mix. So what is personal data then? Because we are saying data protection only deals or covers with personal data. So any information relating to a natural person or an identifiable natural person, any attribute or any characteristic that you have or that describes you, name, age, gender, cultural profile, your health information, your income, your social status, family origin, all those things are personal data. However, our biggest focus is not on just personal data, is on this sensitive personal data. So these are the ones we're calling special categories of personal data that need more protection due to their sensitivity. So they are sensitive because they can be used to cause bias or harm or loss to a subject. And therefore, they have to be protected. And you will notice those who have interacted with the act, there's something we call a data protection impact assessment. Now, not all entities or operating, let me say, industries are required to do a DPIA before registration, but some specific ones like health, education, telcos, telecommunications, financial services are required to conduct a DPIA by the Act and to furnish the ODPC with the information because of the sensitivity of the nature of the data they hold or the sheer volumes. Like telcos, they have millions of subscribers. So if information could be lost, then it would create a problem. But with the telcos also, it's because they've also heavily entered into the financial space or financial services space. And therefore, if M-Pesa transactions were to be leaked, I think there will be a hula baloo all over. But this is an example of sensitive personal data, health status, ethnic or social origin, race, family details, biometric data, spousal data, and the like. Now, you notice name is not here, and most of the time I get that question because we tend to feel this side of the Sahara that a name is sensitive. However, names are not considered sensitive personal data, one, because they could be shared or they could be, they are not unique. So you cannot uniquely identify a person using a name. There are people who could have exact same names. Just like me and my cousin have the same name. He's also Duncan Nyale. So you can't really identify which one we're talking about. But if we talk about things like an ID, so ID number is sensitive, although not directly, because if I give you an ID number of a person, it's not useful. However, you can use it or you can process it to get more information about that person. So all these things like number plates of vehicles can also be used to generate personal information. So when you're parking somewhere and they're taking videos or photos of your car and your license, is that legal? I think that's a conversation we can have around that. Now, on processing, according to the Act now, so those in ICT, don't remove your ICT mind a little bit. We look at what the Act says or defines processing. So processing, according to the Data Protection Act 2019, is any operation performed on personal data. So the whole data management life cycle, from collecting, how you organize the data, how you store it, how you retrieve, how you transmit it, how you share it, how you delete it, is called processing. So processing is the whole data management life cycle. Unlike in ICT where you get data, then you process it into information. So for the ICT heads, do not think of it from an ICT perspective. Processing, according to the Act, is any operation performed on the data, including collecting it. The moment you give me a questionnaire and I fill my personal details, or you give me a loan disbursement form and I fill my details, you give me a registration form, I fill my personal details, you give me anything for any service, I enter a building and I have to surrender my personal details, you are already processing that data. You don't have to say, because some organizations or people say, processing is after I've collected it, then I use it for something. No, you have to be very clear about what the acts hold, because it's unambiguous. If you don't do that, you'll find yourself on the wrong end of things. So if you collect data, even if you don't use it, by virtue of collecting it, you have processed it, and therefore you are liable according to the Data Protection Act. Now, something else important. Lawful basis for processing personal data. So you have gotten this data, you have collected it, and you want to use it. Now we are saying you have to use it fairly, properly, or legally. Yeah? Now, what are the ways that we can be able to legally use data? Of course, the first one is consent. Consent is supreme. Once you have consent, then you can be able to do whatever you want with that data. No one will ask you a question, because I must say, as much as you're collecting my data, I remain the data owner. So the data subject is the data owner. Never at any point does the data controller become the owner of personal data. You're just a custodian. Eh? And that's why the data subject has rights. Therefore, as the data owner, if I give you consent, you can go ahead and process it in the way we have agreed. Nobody, even the data commissioner, can ask you anything. However, there are some instances where consent might not be available, might not be practical, and probably it may be counterproductive to try and get consent first. And therefore, all the other things below consent make up what we call exemptions under the Act. So these are the other ways you can be able to process personal data if you do not have consent. So like performance of a contract. So if it's a contractual obligation for you maybe to supply records within your system to maybe a regulatory body or something, then you have to do that. Like in the SACCO sector, I think they have to submit details of directors of SACCOs to SASRA, including their ages, how long they've been there, how much they got. That is sensitive information, and all that. So, but they have to do it because that's what the NINI says. Then the issue of legal obligation. So legal obligation is where probably you have a constitutional mandate, or you are required by the court to do something, especially like in the court. If I get a court order, or the DCI has a court order and they subpoena Safaricom to get my phone records for the last 3 months, then Safaricom does not need to seek consent from me. They just supply the data as under legal obligation. Vital interest of the data subject. For example, if you are lost, or maybe you are sick or something, or maybe you fainted and you need treatment, or maybe you've been in an accident and we're transferring you from one hospital to another, then your vital interest to try and make you survive supersedes your right for data protection, and therefore we can be able to use your personal data, blood type, give whatever it is, blah, 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 and have you transferred from one hospital to another, because at that point in time, it is not practical to seek your consent, and it is not practical to wait and see if we can maybe access someone who can give consent on your behalf. Public interest, one of the hot points of the public participation, because most people felt it could be misused by the security agencies. But basically, what it means is in a situation where there is a matter of grave public concern or interest, like for example, if you are suspected robber who has killed very many people, or like that suspect of the Kware murders, if and at a footwear, we can be able to splash them and look for them and you have no claim to your rights being infringed if you're like that, or you are a terrorist and all that. So we can put your images out there and look for you, and you can't complain. Public authority. So public authorities is if you have given a mandate to do, or you're executing a public mandate. Like, for example, let me go back to the example of KUCCPS, KUPS, that places students in maybe institutions of higher learning. So what KUPS does, it does not generate its own information. It gets student information from NEC. Then what it does is it places all students into either TVETs, universities, or VTCs. So you cannot tell KUPS to seek consent from the students before they place them. And probably most of them are minors as well. So you have to understand minors, anything to do with minors is considered very sensitive. However, because it is a public authority or a public mandate, then KUPS does not need consent from a student to place them in an institution. They will place you either way, whether you want or not. Whether you go is another matter, but they will do it and they do not need to seek consent. Legitimate interest, like for example, if I have a building and I want people to surrender their IDs before they enter. Now, I can do that under legitimate interest. I do not need your consent because at that point in time, the interest of enforcing security of the building and the occupants supersedes one person's individual right to privacy. And therefore, you have to do that. However, there are, of course, because this is a question that comes up a lot, there are, of course, guidelines that need to be followed. There must be a public privacy policy that must be open. There must be a privacy notice. You must be notified how long that data will be kept. If I come here, for example, even to tie that with CCTVs, I've visited a building. I have given my personal information recorded maybe on a digital system. I've been captured by CCTVs all over that building, and I won't go back maybe for the next 7 years. So how long do they keep that information? So I think that's the part that enforcement has not yet begun, but you don't have a claim to refuse it because most people say no, they refuse to comply with the security protocols. That you have no claim. What you have a claim on is you must be told how that information will be handled. Then historical and scientific research. This was another vague one, even at public participation. I'd add journalism as well. It's also here because it seems to exempt historical, scientific, and for journalistic and artistic purposes. But I think the thinking here is, like, for example, just to give an example of the newspaper, if they are doing a story about maybe the dialogue, national dialogue that has not kicked off from Monday this week as was envisaged. They can put a photo of His Excellency the President and all the other protagonists that were there. You cannot now tell them to go and seek consent from them before they publish. So those are some of the things. So journalistic, artistic purposes as well. If I'm doing a book on maybe the growth of corruption in Kenya, for example, I can go to the judicial system and get the first recorded convicted case of the individual, the personal details of the individual who's convicted of corruption, first maybe in Kenya, and punished. And I can publish that in my book, and they will have no claim to me having infringed on their rights. That's basically what that means. Then as we move towards the tail end, so that we have some time for questions, the concept of consent, like we said, consent is supreme in data protection. So what is this consent we're talking about? Manifestation of express, underlying express indication of a subject's agreement, the processing of their personal data. So it must be direct in that I give it myself as a subject or my legal representative, who can be like a lawyer or a legal guardian if someone is a minor, okay? Now, it must be direct, that is one. There must be a choice for consent to actually hold. A choice means For example, if I want to open a bank account, I can opt in that they use my personal details for banking services, they use my personal details for statistical purposes, they use it for research purposes, but I don't want them to send me promotional messages. So I should be able to choose the three and deny the fourth one, and still get the service. Not what we see now, where you have 64 pages of terms and conditions, then you're telling me to sign on page 65 that I've accepted everything. There's nothing like blanket consent. You should get consent for each specific activity that you want to undertake. You want banking services? Yes. You want marketing? Yes. I choose. You want research? You want statistics? I choose to allow you. That's how consent should be. So consent is one of the biggest challenges when it comes to complying with the Act. I think most organizations are struggling with structuring maybe data capture documents that have admissible or acceptable consent clauses. And those are some of the things we assist with when it comes to working the data protection journey. So you are required as a controller and a processor to obtain consent before processing personal data. And we said processing begins from collecting information. So that means you should first get consent, then collect data. Ideally, that's what the Act says. But is that what we do? The sheriff is out there. We need to comply, because right now I think the focus is on sensitization and equipping the people, but enforcement is surely not very far. And we have already seen that being as litigious as we are, Kenyans, we cannot rule out many data protection infringements being reported to the Data Protection Commissioner. Let me finish with this final slide on the principles of data protection. Now, data protection across the world revolves around these 7 things. That is the lawfulness, fairness, and transparency of processing. And I think we had mentioned a little bit of this. So you cannot collect data. Of course, you cannot use it for illegal purposes. That covers the lawful part. Then you must be fair. And I think I've already talked about fairness when we're defining data protection. Don't use any personal data for any biased purposes. And finally is transparency. Transparency ties very much into consent. You should be clear with me. You are collecting this data. Why are you collecting it? To do what? Until when? Can I opt in? Can I opt out? Because one other thing about consent is you must have the same opt-in and opt-out mechanisms. If opting in, I click one button to opt into something, I should also be able to click one button to opt out. Not opting in is easy, then opting out is difficult. We call that affirmative action in consent building. So you must be transparent. Then data minimization. So you need to collect only the data that you need to execute a mandate. Don't collect more information that you might need. Like, for example, if you are recruiting interns and you ask them for their marital status, you should be able to explain why you need it. Why do you need marital status for interns? For what purpose? If you can't, leave that out. Purpose limitation is what I had mentioned earlier. When you get consent to do processes A and B, you limit your purpose to A and B. Do not repurpose the data. Like, for example, that banking examples I was giving, if I've given consent for banking services and research, do not go ahead and market or use my details for marketing because I did not agree to that. If you do that, then you have broken the principle of purpose limitation because you have repurposed that data. Storage limitation. So you are not advised to keep data indefinitely unless, of course, it is very necessary to do so. So there are instances or organizations store data permanently, but more often than not, probably not. Like, for example, if an employee of TBS transition, they find greener pastures and go, how long should we keep their data before we forget them completely? That's the concept of storage limitations. So you must think of having a data retention schedules in your policy, or you have a separate data protection data retention policy, I beg your pardon, to handle this particular principle. Data accuracy. So what the Act says is you, as the controller, should take initiatives to ensure that the data you hold about a subject is as accurate as possible. This could include things like, for things like circles and other organizations that have maybe AGMs and national democratic congresses, you can give data update forms. So maybe someone's telephone number changed during the year, they can be able to change it. Or you can be able to adapt, and so on and so forth. Integrity and confidentiality, just think of security when you see this. So how are your data protection safeguards? Are you handling data with the integrity and confidentiality that is required? How many people see it? How many people can manipulate it? How many people can use it? How many people have access to it? How do you regulate all that? So that's an issue of safeguards. Then finally, accountability. Now, accountability basically is ensuring that you take responsibility for all the other 6 principles. So you of course become accountable for using data transparently, you minimize purpose and all that, but more importantly is taking initiative when faced with unwanted circumstances. Like, for example, if there's a breach of data, what is your breach response plan and mechanisms? There are legal requirements for you to do. Like, for example, if your data has been breached, processor has 72 hours to report to the controller, and then the controller has 48 hours to report to the ODPC. And that is what the Act prescribes. So are you accountable enough to self-report yourself if you've been breached within the 48-hour period? If you don't do that, then you don't follow the accountability principle, and therefore you have failed to follow the Act, and you can be surcharged. That being said, I think there's quite a lot within this space. And as we say, this is just the first of several webinars we're hoping to free webinars rather to go around just to equip people and sensitize people on data protection. And of course, I'm hoping to be able to assist organizations navigate this journey. We have several people, organizations we have already assisted. You can go to our website to see what we do and who we've helped so far. And you can always drop us a shout at any time at info@tbs.co.ke, or even personal email. I think it was in the second slide. I'll go back, dingali@tbs.co.ke, and we'll be ready to assist you. So I think back to Emmanuel for maybe a Q&A. Thank you, guys.
Thank you so much, Director, for that insightful presentation on data protection. I hope up to this point, all of us have a light on how data protection is all about. I would now like to invite questions on areas that you want to be clarified, or any question that you feel you need to be helped kindly. The floor is open for questions. Any questions?
So maybe you can raise your arm if you have a question, and then we can be able to see you.
You can also chat. You can forward your questions in the chat board. Any questions?
I don't know. Can we be heard? Maybe just confirm you can hear us, and then.
Can you hear us?
Okay, thank you. I think Kevin has confirmed from the chat that you can hear us. So if there's a question, you can type it in the chat, or you can unmute or raise your hand so that we allow you to unmute and ask it. Okay. Thank you, Kevin, for confirming.
We're waiting for your questions, good people.
Okay, thank you, Kevin, for your question. I can see it in the chat. You're asking, is sharing music as a crime as per the acts? Is sharing music a crime? So the question I will ask is, where is this music coming from? Because if it is already publicly accessible, anything that is already publicly accessible, you have no claim when somebody shares it. However, if you even share music that maybe has been produced and has not been released yet, I think that is outside the data protection. What you'll have broken down probably copyright law, which is a criminal thing in another act, not a data protection act. So it's not within data protection. I think that's the copyright law. So straight up, this is outside data protection.
Thank you, Kelvin. Thank you. I hope the response was okay, unless you have more questions or more clarifications that are supposed to be made, Kelvin. Any other question?
Yes, hello, hi.
Yes,
Hello.
go ahead, George.
Yeah, so thank you very much for the presentation. So I was wondering, do you also look at how the data is stored in a database? So for instance, you collect information, you collect personal information about people, eh? Do you also
Yes.
look at how it is stored in terms of whether you are encrypting that data, those kind of things?
Okay. Thank you, George. I hope you're done. I'm not cutting you off.
Yes, I'm done with the first question. First of all, you can answer to that, and then I'll ask the second one.
Okay, that's fine. So that's the safeguard bit.
Mhm.
Now, it is not directly looked at by the ODPC in terms of enforcing that you have to use this type of encryption or you have to store data like this. The Data
Mhm.
Protection Act is more self-regulating. What you need to do is to define the safeguards that work best for you as an organization, and that's where the DPIA comes in. Then once that is documented in your policies and your DPIA, you furnish a copy of that to the ODPC. So if there's an infringement now and there's an assessment that is, or a forensic investigation, what the ODPC will look at is what are the safeguards that you said you have or you defined and what is on the ground. That's what will happen. So if you say something you've not done, then you'll fall afoul of that during periodic investigation. But ODPC will not come and say you have to use this type of encryption or this is how you need to store data. There's that leverage allowed for organizations to tailor make their data protection safeguards as long as they meet the principles that we have discussed earlier. So yes, but not directly. I hope that helps you in some way.
Yeah, that is kind of okay. I guess maybe when that time comes, we may need to unpack it more.
Yes, definitely. We'll definitely go there. We'll do a series of these. In fact, there'll be probably one webinar strictly on safeguards. The next one, I think, we'll do rights, we'll look at obligations, we'll look at safeguards, and all those other things, including complaints handling and all that, as separate webinars. Yeah.
Okay. Yeah, because I'm also looking at a scenario whereby fine, if I have the required licenses, let's say as a
Yes.
controller and as a processor,
Yeah.
but I'm also integrating the system with other third-party systems,
Yes.
and they're consuming that data that I have stored. So what are the regulations around that as well? So
Yeah. I think that's a very good concern. And you remember me mentioning third party, yeah? There's a very
Yes.
thin line between a data processor and a third party. So this third party, or this, let me say, the systems you're integrating with, are they performing any role on your behalf?
Yes, they are performing other services that I'm personally not performing those services myself, but
Okay.
I need those services from other third-party providers.
Okay, so they're supplementing you in a way.
Yes. So you see,
That's
for example, let's say
yes.
like let's say I want to send SMSs to my clients, for instance.
Yes.
You see, myself, I do not have the SMS service. That SMS service is housed somewhere else, but I need to
Yes.
use this data that I have, maybe the name and some other criteria.
Yeah.
Yes, something like that.
Yeah, I get it. So what needs to happen, is when you engage, because that qualifies to be a processor, have within your contracts or service level agreements, data protection responsibilities. Be very clear on what mandate you have given them for that data, so that if they do something outside your instruction, they can now be held culpable as data controllers in their own right. Remember, we say the controller determines the purpose and means of processing data. So, for example, if you want to send maybe messages to people you have consent on your services, then this organization accesses your database and decided to market their own products. You didn't tell them to do that. Okay.
Yes.
So as much as you are the data controller, your clients will follow you. You are the one they know. But in the course of the investigation at ODPC, you will have to demonstrate that actually, yes, this is my processor, but I told them to only send SMSs to my clients that I have consent on my products. They went ahead and decided to do something I did not mandate them. So because they did that, they have taken on data controller responsibilities. They will be charged as data controllers in their own right by taking it upon themselves to determine what this data can be used for. I hope that's clear.
Oh yeah, that's clear.
Yeah. But the trick is, George, make your contracts watertight. Be very clear. What is it you are allowing them to do, and what data they are accessing, and what data protection liabilities does each hold? Ukikuwa hiyo, yourself, you are home and dry.
Okay.
Yes.
So thanks.
Okay, Esther Shege, I'm taking a few from the chat. Is consent form valid even after an employee leaves employment? I'm not quite sure what you mean by. Oh, okay. So you gave consent. You gave consent when you are joining the institution. Then you're asking if that consent is valid after you leave. I think if I understand you right, probably that's what. Okay, thank you. I'm seeing your mic is on. Esther, yes, go ahead. Just
Hi.
shed light.
In our organization,
Yes.
we normally have standard operating procedures
Yes.
that got human face, or I would
Yeah.
say an employee photo on them. That's
Yeah.
illustrating how an activity should be done, or a procedure.
Yeah.
And normally we give them.
Sorry, you normally give?
a consent agreement,
Yes, yes,
allowing us to use their photos on those SOPs.
yes.
But what I'm struggling with is in case that employee leaves the
Yes.
organization,
Yeah.
should we include for the period on the consent form when that SOP is to be used, or should we redo it once the employee leaves the organization, just for us not to expose the organization?
Okay. Okay. What
I'm
I'll say.
referring to the case that happened with the Express
Yes.
on the billboard. The employee, they used a photo for an ex-employee who later on came to claim that he's no longer an employee of the organization. Then why should his photo be used?
Okay. Yes. Now I've got a new clear now. Now that is solved by the purpose of collecting data. You see, at that point, when you're collecting that data, was to facilitate this subject as your employee. So if they cease to be your employee, then you remember me talking about data retention policy or data storage principle. We'll now go back to your data retention schedules. What does your policy say? For example, if yours says that you will store data 3 years after an employee transitions, then you can be able to use it within that 3-year period. However, if you use it in the 4th year, then you'll have been fell afoul of the law. So it is not a one shoe fits all. It depends on what your policy says. So the problem will come when you have no retention schedules. Because now it's a he said, she said kind of thing, and it is who proves the stronger or presents the stronger merits of the case. So I think that could be sorted out by having very clear data retention policies that once you transition, we keep your data for 5-7 years. Of course, you have to justify or indefinitely. If you have a reason to keep it indefinitely, then you'll have to justify that, and then you can be able to use, because I might exit. Like I've been a director in some institution, and I exited, I think early this year. However, for the financial records for the last financial year, I am there. Because during the period under review, I was actually a director there. And if anything happens, I can still be held culpable. So just because I've exited does not mean processing of data needs to stop immediately. But to be safe, have it in your data retention schedules clearly. I hope that helps you, Esther.
Thank you.
All right, Karibu. I'm seeing another one from Teresia. How long should one store personal once the principal is deceased? So this answer is more or less the same to what I've given Esther. The policy holds for both. If you transition or you are deceased, you handle the data the same way according to the policy. If your policy says 3 years, then you can hold it. By the end of the 3rd year, you have to completely remove or forget this particular subject. I hope, Teresia, that answers you as well.
Teresia, you okay?
You can even type if maybe you're having challenges with the mic.
Any more questions?
Okay, Teresia, thank you. I'm happy to know that you've been able to get a good answer. So our website, I'm putting it in the chat. You can go there, check us out. If you need anything to contact us, our email is also on the chat. Okay, Roy, I'm seeing a question. But still, I've posted our website and email in the chat. You can check us out. What if on the consent you state that any picture is property of the organization? Now, there's always this question of personal data and organizational data. Now, organizational data, just to give an example, is like if, for example, if there's a disciplinary proceeding for an employee in the course of their stay in an organization, and that information makes its way to the personal file. Who has rights to that information? Can I go and demand my personal file from the HR office or not? Now, what you're asking borders on what qualifies to be this or that. Now, the issue is this, my image, an image of me, does it qualify to be organizational data or personal data? From where I see it, it's very clear that is personal. Remember, we said just because you have my information, it does not make you the owner of that data. The owner of the data is always the data subject, or the owner of personal data. So a photo being of me, that is personal in nature, so that will be mine. If you want to use it, you must have consent. And that is why Machakos University, just to name one, and that kindergarten were fined for using images of students to market themselves on billboards. And the argument was that they signed a media consent form. It doesn't work like that. An image is very sensitive. It's actually more sensitive than a phone number. It's more sensitive than your name because I can clearly see it's you. There's no mistaking. It identifies you uniquely and directly. And therefore, that is personal information. For that, you need consent. And the other thing is just to say, when you are doing marketing of any kind, the act only allows you to use consent. I think that's where most of the organizations that were fined didn't get it. They were saying, they signed a media consent form and therefore we can use it for anything. No, according to the act, you can use it for other activities. But when it comes to marketing, you must get direct consent. And I think that's where most are falling foul. So Roy, iko shida hapo. You cannot take someone's picture and say it is organizational information. Thank you, Roy. Okay.
Thank you, Roy. Any other question?
Thank you too, Roy. I'm seeing your message. Appreciate it. Okay, so maybe we still have some time. So those who have questions, you can stay back and we'll be glad to answer a few of your questions as we go. Don't feel to leave in a hurry. But for those of us who maybe have other engagements, we don't want you to keep you here and probably you are fine however you are. So from us is to sincerely thank you for gracing this webinar. As we said, we'll be organizing many more and we'll be debunking most of these theories that we have in data protection and basically just trying to improve the landscape of data protection. If you need assistance as an organization on any matter data protection, we are one-stop shop for data protection. We do DPIAs, so data protection impact assessments. We do assessments and audits. We do data protection training and sensitization. And we are accredited, by the way, by the Office of the Data Protection Commissioner to train and certify. Yeah? We have a 5-day training course that we offer. And we offer certificates accredited by the National Industrial Training Authority and the Office of the Data Protection Commissioner on data protection. So I think that should go out there. We also offer external data protection officer services. So some organizations, maybe they are small or they don't want to have an internal data protection officer. The law allows you to outsource that. So we can take on all your data protection liabilities and compliance issues if you need that. So feel free to reach out to us anytime. We'll be glad to help you, even for the occasional, maybe just a quick one. Maybe you want to confirm something about data protection you're not sure of. we are very much okay to assist you, maybe make a decision. So you can reach out to us and we'll be able, or we'll gladly help you do that. So thank you so much for attending. You can feel free to leave at your pleasure if you need to, absolutely need to, but you're also welcome to stay with us until the very end so that we can all benefit from the questions that are being asked at the deliberations. I'm seeing another question here. Oppo, I don't know who you are. You didn't rename yourself, but it's okay. In a scenario whereby, okay, Esther, okay, I'm seeing you're saying I share my phone number. I am putting it in the chat, guys. So that's my phone number. Yes, I have Esther shared it, so you can get it from there. Let me go back to the question. Thank you, Esther, as well. From Oppo, in a scenario whereby we had pictures of former CS in our websites attending our AGMs and they are no longer the CS. Can they sue us for using the pictures? No, they cannot be able to sue you because they refer to a time when they were actually in office, and from where you sit as well. You know, when it comes to public figures and public information, it's a bit tricky. Like what I was telling you earlier, the president cannot complain that probably he's appearing in a photo in the headline of a newspaper article that is giving a grave review about the riots in Kenya because of those exemptions that we have. So no, the CS would not be able to complain. They have no grounds. You can cover it in exemptions or even in the public nature of executing the mandate. As long as you keep it to the period that they were there and you are factual, there wouldn't be a problem. I hope that answers you. You said Oppo, it's written Oppo, so I don't know who you are, but I think you can just confirm that answers you.
Any other question? Any other questions?
Okay, so maybe we'll give it another 5 minutes. If anything pops up, you can ask. We'll be glad to attend to you. If not, or if nothing comes in the next 5 minutes, then I think we will end it there. So be on the lookout for our next webinars. We are planning on maybe hosting one every 2 weeks. So maybe in the next 2 weeks, we'll be having a conversation on rights of data subjects. And therefore, you are welcome to join us in all those. And of course, feel free to engage us, to ask for advice on compliance, on safeguards, and also engage us maybe to help you comply with the office, including matters of registration, of training, of data protection impact assessments, on board us as your data protection officer, and all that. So thank you very much, and God bless you, and stay safe. Thank you, Esther, and thank you, George. I'm seeing your comments as well. Thank you so much. So Emmanuel, you can take it from here. If there's a question, we can deal with it. If not, in 5 minutes, then I think we can call it a day. Thank you.
Thank you, Director. As the Director said, we're going to give you around 4 minutes now to air out your questions so that we can make clarifications and be able to give answers, because the concept of data protection is new. The Act was just enacted in 2019, and they are obligated to follow the regulations that have been put in place so that we can actually be able to comply. So Feel free to contact us. Feel free to talk to us so that we can be able to guide you on the regulations, trainings, and everything that matters on data protection. So kindly, good people, the floor is yours. You are free to ask questions. You are free to chat on the chat board, ask your questions on the chat board, so that we can be able to share and give you the right answers on how to handle data protection. Any more questions?
Okay. Thank you, Evans. I've seen a question. I joined quite late. I'm unable to listen again on that. If yes, kindly share them. Fine. We'll do that. I think what we'll do once we host the link, we can send it to all of you. Whoever wants to revisit can be able to do that. So yes, Evans will do so. Thank you.
Thank you, Evans. You're always welcome. Feel free to contact us. Feel free to talk to us at any time. As I have said, we offer trainings on data protection, compliance assessment, and audits. We do data protection impact assessment. We also do data protection sensitization and training. So all these is per the Act of 2019. And per the regulations, we are supposed to comply as organizations, institutions, and businesses. So this is a platform, or this is the most opportune time for us to be able to familiarize ourselves with the data protection procedures. So for those who have just joined, we are TBS Tenacity Business Solutions, and we offer these trainings. And as the director said, we are accredited by the Office of Data Protection Commissioner and NITA, which are legal government bodies that give you the mandate to accredit other organizations to comply with data protection. It is a new concept, and we wish to debunk that concept to you so that we can all be able to comply. Any more questions, guys? Then up to this point, I do think now I'm going to end the meeting. Yeah, in the next 1 minute, I'm going to end the meeting. If there'll be no any other question, but we really appreciate your participation, and we also look forward to have several engagements with you. Any question? Any other question?
Okay, guys, have a wonderful day. Enjoy and keep safe.
Thank you, Director. Thank you all. God bless you so much. Thank you.